states. Here's the latest. The latest is potentially the inclusion of the PRO Act in the second whack at a budget reconciliation bill that the Democrats may put on the table, or in the event that Kristen Sinema and Joe Manchin are pressured to vote to obliterate the filibuster, then this is something to be seriously, seriously concerned about. The PRO Act is the giveaway for unionization, big labor, that begins but does not end with the total elimination of right-to-work protections in the 27 states that have right-to-work laws. And Mark Mix is on the phone to talk about this. He is the president of the National Right-to-Work Committee. He's also the president of the National Right-to-Work Legal Defense Foundation. Holy mackerel, is this ever a big labor playground of legislation?
Indeed it is, Vicki, and it got introduced last week with 198 co-sponsors, including 3 of your members of Congress. It's got a couple of Republican co-sponsors. This is a little less than it was introduced with in the last Congress, but it still is a threat, to your point. And certainly in the House, there's an expectation. This bill passed with 224 votes back in February of 2020. It's the Senate where is the stopping ground. And to your point, Senator Schumer and others are thinking about how they can manipulate the Senate rules to make sure they can get this through on a simple majority vote, with perhaps the Vice President breaking the tie, and that would be a radical change. The bill is as you stated, its first priority is to eliminate all right-to-work laws and give union officials the ability to force workers to pay them a fee in order to work in America. Right. It's outrageous.
That's not, and you know what? Believe it or not, that isn't the worst of it. That isn't even the worst of it, and that's really bad. This is a bill that's so bad. Let's see if we can get through some of the more alarming provisions of this bill. So you have got the card check provision, so not just an elimination of right to work, but also the ability to circulate cards and essentially loom over people. And if you sign a card because you're afraid the union steward is going to beat the crap out of you, that is essentially an affirmation that you want unionization without even having a secret ballot vote.
That's correct. That's in there. It's been tweaked a little bit because what it says now, if the employer interferes in any way in a union organizing drive, then the NLRB can impose unionization with cards. But it's the same thing, Vicki. It's eliminating the secret ballot, but because the unions will make that claim in every single organizing drive that they run.
Which is part of this bill as well. That if you go down on the provisions of the bill, if labor complains to the NLRB that the employer, all labor has to do is complain that the employer is getting in the way of union certification, ba-bam, National Labor Relations Board can order a card check unionization just like that.
Correct. That's absolutely right. And they another provision in the bill would stop an employer from communicating with workers about the impact of unionization in the workplace. So that's in there too.
So this is all insane. So your employer can't say this is what's going to happen if, in fact, we are forced into unionization. Because if your employer says that, the labor union complains, then you have a card check unionization. It's not just that, though. It's also using the ability to unionize across multiple employers as well to try to utilize, I guess, the power of what? The power of crowdsourcing. If you can't get a substantial number of people to agree to unionization at one level, well, just keep expanding the number of employers that you're going to target.
Yeah, that's right. There's provisions in here that would basically overrule the joint employer rule that's been in effect recently, and that is that, like for example, a McDonald's franchisee would be able to sue McDonald's corporate if a McDonald's franchisee stood in the way, and it would basically make this kind of joint employer rule now part of the unionization drive, which would allow them to go out and get different group bargaining units and amass them in one big unit and say that the McDonald's corporate is being a bad actor. And who knows what goes on from there? I mean, this idea of forcing employers and forcing employees into unions is something that is just absolutely throughout. It's knitted into the entirety of this quilt of labor union privilege.
So tell me as well about the ability to actually force unionization on independent contractors. That's also something that's contained within this bill.
Yeah, that's right. This is the California, so-called California ABC law. This is the AB5 bill that passed that's now outraged most liberals in the state of California, and something they wanted to roll back and have tried to roll back because the implications are extremely dire. What this says is that there's no such thing as independent employees anymore. So, example, if you have a car and you've decided to sign up with Uber or Lyft, and you go out and you say, okay, you know what, I'm only going to drive on Sunday nights between 7 and midnight, and I'm not going to do any work the rest of the week because I got another job. All of a sudden, you are now an employee of Uber and Lyft and can be unionized. You're no longer an independent employee. You're now an employee, and this is something that started in California, actually started in Seattle when the Seattle City Council passed a resolution saying that if you were an Uber, the Teamsters would unionize you. And we've obviously filed a suit on behalf of dozens of Uber drivers. The other folks filed antitrust litigation, and the bottom line was that it wasn't legally, it was stopped. But this is in the bill that would basically eliminate independent kind of gig worker employees and put them all into units subject to unionization.
How do you stop this if it gets passed? Is there anything that you could do? Because this essentially changes the way the NLRB operates, and it would be an act of Congress. So where would the constitutional claims or the court challenges come from?
Well, we certainly would be involved in litigation and helping employees. But you're right. If it's statutory, the courts tend to defer to statutes unless the statute has gone crazy. And under the National Labor Relations Act, they make the argument that the idea of the National Labor Relations Act is to promote unionization. They talk about it's for employee rights. Well, that's a bunch of nonsense. It's for big business and big labor, and it basically is two cartels that whoever has the power at the moment gets their way, and the piece of the equation that's left out is the employee. And I would suggest to you there are reasonable litigation claims on constitutional grounds. Think of Janus. I mean, we got a constitutional decision in the Janus decision about whether or not government employees could be forced to pay dues or fees to work for their government. Now, obviously, the private sector and the public sector are different, and the argument's a little bit different, but we believe the First Amendment applies. I can't force you to associate with someone. That applies universally, whether it be the private sector or the public sector. So there'll be litigation, but the secret is to stop the statute, and we can do that in the Senate if the rules will hold up as we're currently operating under.
So let's talk about, again, Schumer is talking about manipulating the rules. So reconciliation typically is only for fiscally related, budget-related bills. But what Schumer wants to do is change the rules that would permit, non-budget-related measures to be passed with 51 votes. And this was a scramble to reintroduce this, I think, because the expectation is this would be one of the measures that would be included in the second whack at reconciliation in one of those giant reconciliation budget omnibus bills.
Yeah, I think that's right. And the one hurdle they have, interestingly enough, is the so-called Byrd Rule. That's the Robert Byrd Rule that I think was initiated back in the 1980s when he saw this coming. I mean, this is Democrat Senator Bob Byrd from West Virginia said, look, the budget reconciliation process is for fiscal matters only, and anything that's not germane to the fiscal issues relating to the budget are out of order. And basically what happens here is someone stands up on the floor and says, I want to amend the PRO Act into this budget reconciliation bill. There would be an immediate objection. They would ask a ruling of the chair. The parliamentarian would say, no, this is a violation of the Byrd Rule, and therefore there'd be a vote on whether or not the parliamentarian was right. And in theory, they could actually overturn that with a majority vote.
Right.
And I think that's what Schumer's up to. They realize that their agenda is radical. They realize that a lot of folks across the country, it's like Joe Biden and Richard Trumka. Richard Trumka did an interview with HBO, I think, over the weekend and said, we sure wish Biden wouldn't have put 1,000 union jobs in jeopardy or fire on the unemployment line, and then 10,000 more. And he did say, though, I wish he didn't do that. But yet, every union in the AFL-CIO endorsed Joe Biden for the presidency. And they knew this was coming. They knew it. He admitted in May that he was coming.
Something else, yeah. and I mean, if you read through this bill, it looks like the unions barely have to do any work any longer to essentially get unionization wherever they're attempting to organize. That the only thing is that they still actually have to kind of sort of organize. But the bargaining in good faith, allowing the NLRB to voice binding arbitration on first contract on an employer based on a union allegation that the employer is bargaining in bad faith. Well, that's pretty much going to be every single time you've got an attempt at unionization, the union will say the employer is bargaining in bad faith. If you've got a rigged NLRB, then you're good to go. You don't even have to really work that hard any longer.
Yeah, that's right. And it took the new president, only 23 minutes to make sure we had a rigged NLRB. I mean, he, into his new administration by firing the general counsel who had 10 months left on his term. And the implications of that over the last 2 weeks have been very interesting. In fact, it was very flattering to us at the National Right to Work Foundation because the new acting general counsel that came out of Chicago issued a new memorandum to all the regional offices across the country saying that you have to handle these cases different than the previous general counsel said, and 4 of the 10 issues were directly our cases at the foundation. So, we're just a small little guy operating out here, but we did get the attention of the entire National Labor Relations Board and the Biden administration because our progress had been so dramatic over the last 4 years in helping employees exercise their rights. But to your point, Vicki, that's right. This basically stacks the deck, and it makes it virtually impossible for an employer or employees to avoid unionization, and it certainly immediately would stop any employee from exercising their rights under what would be then non-existent right-to-work laws in 27 states.
Yeah, that would be the thing, because all of that's gone. So you're losing that, legal structure that you're able to lean on. Your personal information will be made available to the unions. Your employer will be accused of bargaining in bad faith. If it's coming to your employer, it is likely to be successful at your employer if, in fact, this passes. Because, again, the unions don't have to do much in the way of actually getting a majority of people to actually want to join the union. This is scary stuff. It's not the only thing that could be done through a manipulated reconciliation process. If, in fact, the Democrats in the Senate vote to overturn the parliamentarian, that's how it would work, right, Mark?
Yeah, that's right. The Byrd Rule is in effect, and it basically stops the debate or the addition of any amendment that's non-fiscal related to the budget process. But if they change that, then it's Katie bar the door.
Yeah.
Everything's then germane. Whatever the parliamentarian or the majority says is germane can be part of that process.
Exactly. Think about the massive number of things that could be part of that process. Mark Mix, where can people find out more? Because I think a lot of people have no idea what's going on with this particular piece of legislation.
Yeah, we've got an issue briefing paper on it at the nrtwc.org, nrtwc.org. You can see the legislation. You can see who the co-sponsors are. You can see that all on that website if you go there. And you can see what your rights are in right-to-work states and non-right-to-work states there as well.
Thanks for being on the program today. The president of the National Right to Work Committee and the National Right to Work Legal Defense Foundation, Mark Mix. We need to take a break here.